Trademark is your business name, right? And it can be your business name, or it can be a little picture and your business name. Whatever it is, you are using it in commerce for the purposes of your business. Hi, I'm attorney Demitrus Evans of the Evans International Law Firms, and I'd like to talk to you about trademarks. So I just hung up with one of my clients who is having a major problem with her trademark. It's trademark infringement. And not only is it trademark infringement, but she has received an opposition, which means a whole slew of things. So come with me, let me tell you how I will really attack this. I just got off of the phone with my client, and my client is having a bit of an issue because someone is utilizing her trademark. Now, this is important that she is aware of it. Once you've filed for a trademark, or if you have a trademark, old or new, you need to follow it and make sure that no one is using it. Your trademark is what represents you and your company in commerce. So trademarks, before they're actually registered, you can use this TM. Once they're registered, that means the U.S. Patent and Trademark Office that is going to tell you, yes, you have this trademark for a number of years, you are able to use the R with a circle. Now, the trademark is your business name, right? And it can be your business name, or it can be a little picture and your business name. Whatever it is, you are using it in commerce for the purposes of your business. Once you file it with the United States Patent and Trademark Office, it's like there's a lock, right? This TM is going to turn into, well, you're going to use it until they say you can have it, then you'll use the R. If someone then decides to use it, it's really theft. In trademark or intellectual property, we call that theft infringement. So that means that someone is infringing upon something that really belongs to you. If that happens, right away, you want to give us a telephone call. But once we get that call, we are going to look at what your mark is versus what they are doing with it. Let's say they are using your name, but they actually take out a couple of letters. Or they are using your picture and they use it in a different color, and you didn't specifically say, I want to own this color, which is something in the application that you would have to say. But we are going to look at all the documentation to make sure that there is really some infringement. Once there is an infringement, we are going to send them a letter and say, you must cease and desist from the use of this name or this mark in commerce. If they decide that they are not going to cease and desist, then we are going to file a federal case in the United States District Court. Once that process is triggered, then we want to get all of the filing fees. Now we're going into discovery. There are motions, there are deadlines, and ultimately there will be a trial. Now, I do have to tell you this. For the most part, once you call up that company is going to hire counsel. If they can't hire counsel, then we may talk with them, explain what the situation is. Depends on how deeply they are into it. If they are reasonable and we know that we can prove this case, then it would make sense for them to say, we will cease and desist from the use of this. But if they say, no, we've been using this, we really don't believe we're infringing, we're in a full-blown battle, and it's going to take place in the United States District Court. Now, I do want to tell you what my process is. So, gonna put on my mask, come over here, let me talk to Peyton. Peyton, I wonder if I could just talk to you a minute about how we're going to handle the situation of an infringement. So the client has just called me, and I've now described exactly what process I'm going to go through. What I want to do now is I want to send them a proposal. All right, I'm going to scoot back just a little bit. So I'd like to send them a proposal telling them what I believe the goals should be. Once I know what the goals will be, then we can get our fees and the cost of the trademark case, we can get that sent to them, and then we'll begin the billing. But I just want them to know, from your perspective, what we are trying to do with those two documents.
Yeah, so we will, the proposal will help line out some of the objectives, and we can get an estimation too for like, some of the time it's going to take, all the correspondence with them, as well as the opposition. I would imagine if we got a infringement case here, then there's going to be some talks with the opposing attorneys just to kind of come to some consensus. But I can start drawing up some estimation of costs and time, and so that way everybody's on the same page going forward if this is something we're going to help them out with.
So there is this issue, thank you, Peyton, there is this issue of lawyers and how much they charge for an infringement case. So like Peyton just explained to you, every case tends to be different. If we can clearly look at it, and it's probably something that you could clearly look at too and say, yeah, definitely you're using this mark, then it might be cut and dry, and it may only take an hour or two to figure out, and before that other side would say, yeah, I'd just like to settle it. But if it's something that is going to take me and my office 40 hours of time, then it will be more expensive. So lawyers, for the most part, in intellectual property, as well as any type of civil case, they're going to look at how much time it will take for them to get through this process and come to the goal. So your goal could be, I just don't want this person to use it, or it could be, not only do I not want them to use it anymore, but whatever monies that they've made off of it that should have come to me because it's my mark, then I want them to pay me. So looking at your mark, we want you to be successful in what you think is successful, not what I think is successful, because I love trial, but maybe you don't want to go to trial for whatever reason. You don't have time, or you don't want to go to trial because it's just not worth it to you. I have had very, very rare instances where my client will say, it's just not worth it. I think if I can change my mark in a way that that just adds something, or I can add something to it, or I can take something away from it, and then there's no issue, that's what I'll do. So it's going to be determinative based on what your goals are and what's important to you and your company and your business success. And obviously, if you're successful, then that means that I'm successful, and then we've done our job.